Hello and good afternoon. This is second in our exclusive interview series, which NDA has initiated. We are trying to talk about various topics dealing with bilateral investment treaties and the issues concerning investment treaty arbitrations. The first, we launched the series with interviewing Mr. Salim Mulan on the world investment courts and how it will work in Asia. We did that on September 6th of this month. And as part of this series, today we have Mr. Michael Wong, who is going to talk about the effect of corruption, the issues of corruption in investment treaty disputes. So with that, let me introduce Mr. Michael Wong, which of course doesn't require a very detailed introduction with his experience as an arbitrator for last several years and as a counsel in his previous career. He was, of course, a leading practitioner in international commercial and investment treaty arbitration and has adjudicated several high value complex disputes as an arbitrator. He is a senior counsel in Singapore and a barrister at Essex Court Chambers, London. Mr. Wong is also a Chief Justice of DIFC Courts, the Dubai International Financial Center, and was previously the Judicial Commissioner of the Supreme Court, Singapore. With that short introduction, I will hand over this to my colleague Ali Park Banerjee, who is also a senior member of our investment treaty dispute practice, and he would take this interview forward with Mr. Wong. Ali Park.
Thank you, Vyapak. Hello, everyone. Today's topic is effect of corruption in investment treaty dispute. Essentially, how corruption is pleaded. Increasingly, in recent past, the sovereign states are pleading corruption as a defense to investment treaty arbitration, and the contention is that the investment was tainted by corruption. Today, we have Dr. Michael Wong. He's going to shed light on this issue. He has a vast experience of investment treaty arbitration. So, Dr. Wong, if I may start, in your experience, what are the different forms of corruption which you see being pleaded in investment treaty arbitration?
Typically, corruption can occur on both sides. It can occur with the investor, either in acquiring his investment or after he has acquired the investment in the way in which he operates that investment. On the other hand, corruption can also occur on the side of the state, which actually becomes a much more difficult legal problem.
And what are the likely issues that arises if corruption is pleaded in your experience?
Well, let's just take the corruption of the investor who uses corruption to obtain the permission to make his investment in the first place. If and when the state comes to learn of this corruption and a treaty claim is raised, then typically the state will make a challenge on jurisdiction, because nearly all investment treaties only give treaty protection to lawful investors. So if an investor has acquired his investment unlawfully, and corruption would be a prime example of unlawful acquisition of an investment, then the state's position would be, I don't have to offer you any protection because you are not the kind of person that we intended to benefit by the treaty.
Sure. So let me take this a little forward. Uh, so when we say corruption pleaded or an issue of corruption coming up as part of a treaty dispute, uh, obviously there can be a situation where the issues of corruption are very much part of the pleadings or very much part of the past correspondence, or which comes across as part of the dispute in itself, or it comes incidentally to the knowledge of the tribunal. In terms of the effect of either the pleading or coming to the knowledge, typically how would a tribunal deal with it? Is it that they take it up on the basis of suo motu because they get that as part of the information that they are getting, or do they have jurisdiction to even go into it, or they just accept it as part of a fact in the pattern because to get into the aspects as to whether there was a real corruption or not, how much they would have a jurisdiction to even go into it. So if you can give a little idea about how tribunal would react in some of those situations.
I think it's generally acknowledged that in treaty arbitration, as in commercial arbitration, a tribunal has the right, and some would argue even the duty, to investigate corruption, whether or not it is pleaded. Of course, if it's pleaded, then they will have to confront it as an issue. If it's not pleaded, then it becomes much more debatable. But usually in commercial arbitration, it's accepted that a tribunal is no different from a national court, and most national courts have an inherent duty, as the guardian of public policy, not to allow a corrupt transaction to acquire any positive rights under the law. So, from that point of view, there are some people who would argue strongly that an investment treaty tribunal also has the right and arguably the duty to investigate. In terms of case law, there's actually only one clear authority where a tribunal has, on its own motion, actively investigated an act of corruption which was not pleaded. And that is the case of Metal Tech against Uzbekistan, a tribunal chaired by Professor Gabriel Kochman-Kohler, where the tribunal literally took the hearing by the scruff of its neck and called witnesses and ordered them to produce documents because they felt that both parties were not raising the issue of corruption when it was becoming clear to the tribunal, at least, that corruption was involved. And in that sense, the tribunal actually made investigations on its own and put questions to the witnesses which would not have been put by the council, and eventually making findings of corruption. The reaction to this case is not universal in terms of praise. And some people say, of course, this is a beacon of light and an example for the profession to follow, and others think that this is perhaps the slippery slope because it tends to make the tribunal an investigating party, which then would perhaps make questionable their neutrality.
Sure, sure. Thanks a lot. So,
So taking this forward, Dr. Hwang, what is the burden of proof when corruption is alleged?
There was a dispute for quite a while, but I think generally both common lawyers as well as civilian lawyers now accept that for investment treaty purposes and even in commercial arbitration, that the standard, the burden of proof, of course, is always on the person, the party which alleges corruption, like any other proposition. The standard of proof is generally accepted as being described as on the balance of probabilities. But where the nuance comes is that where you have an allegation of any crime, whether it be corruption or forgery or any other criminal act, then there is an issue with the quality of the evidence that is necessary to persuade a tribunal that corruption, fraud, or another criminal act has occurred. Simply because crime does not occur as frequently as lawful acts. So, in order to persuade a tribunal that a crime has occurred, then you have to have slightly more persuasive or cogent evidence um, to persuade a tribunal that they should be comfortable in making a finding of corruption or some other crime. I use the word comfortable advisedly because I like that term because I think it sets the right tone for the tribunal to adopt. And also, it has some jurisprudential backing because this is now the test that is adopted for quasi criminal offenses in sports arbitration, doping offenses in particular. The test is comfortably satisfied.
Okay, so I think just taking the clue from the test in terms of the burden of proof itself, I'm sure there is not enough jurisprudence on the issue of what are the tests applicable for the attribution of responsibility to either parties. Neither there is much of commentary on this issue available. But from your perspective, are there any specific tests laid out or applicable or a guidance provided when it comes to the attribution of responsibility on either parties? Is this something which is very vague, or is there something which at least there is enough guidance as to how the tribunals would behave as we go along? Because this is going to be an issue which is, in my view, very common as we go along in this space.
I think lawyers who practice in this field generally acknowledge that the most authoritative statement of principles, which among other things will deal with corruption, are the ILC, the International Law Commission's draft articles on state responsibility. Of course, state responsibility covers responsibility for a whole number of areas, but corruption certainly comes under that. And very simple terms, the relevant articles of the ILC articles would say that a state is responsible for the actions of its actors who are acting in the capacity as state agents. So the issue basically is whether or not, if you establish, for example, that a senior government official took a bribe, your paradigm case, are you going to hold the state responsible for that before then you try and determine the consequences for the state of that action? First of all, you must decide whether or not the senior government officials' actions bind the state, or the state should be held responsible for the acts or omissions of that particular official.
Sure.
And that can be quite a difficult task. Not a great deal of case law to guide us, but broadly speaking, you can use an analogy of the doctrine of vicarious liability in tort, where most employers would be responsible for the acts, the wrongful acts of their employees, if the employee was acting in the course of employment.
Correct.
So the question is whether or not a corrupt state official was acting in his capacity as a state official.
Or outside.
Yes.
That would be possibly the starting point.
Yeah.
And once possibly it is proved that it was nothing but it was in the course of his duty or her duty that an action is taken which amounts to corruption, then obviously state can't.
And
Yeah.
and what would be the role of the national law in such attribution, if any?
Normally, in terms of treaty protection, the test is under international law rather than national law.
And is there a stark difference between these two? In sense, have you come across a real difference between how national law would generally apply versus how international law applies in this situation? Is there
We don't
examples?
have to. No,
Sorry.
I don't believe there are examples. It's simply because there's a lack of case law on this. What I can say is that up to now, I believe there is no reported case of a host state being held responsible for their employees' corrupt acts in answer to an investor's charge
Okay,
of
sure.
of state corruption.
Sure. And I think coming to a more stage of conclusion here, right? I think one thing is to find that there is an allegation. Second thing is to investigate. Uh, Obvious consequence would be that the investor may be disallowed if investor is also possibly party to such an corruption. Knowingly, unknowingly, we can keep debating in terms of facts. But what are the real consequences of it? Is it that you are simply disentitled and the tribunal ends their mandate, or is it that there is a bigger consequences? Is tribunal obliged to take that a little further, report to people, disclosures, where it all ends? Because one is to just deny the claim, but then there is an issue which has obviously now come to surface.
I think it's a big question, but I think let's start. All I can do at this moment is just to point to what legal areas you need to explore when you can't come and discuss the questions that you've just raised. Where there is an argument about both investor and host were involved in some way in the corruption, whether who initiated it, and if the investor says it was the host or an agent of the host country who asked me to make a bribe and I was only complying with it, how does that affect the interplay? Um, the relevant legal doctrines you have to look at are recognition of a wrongful act, acquiescence in the wrongful act, uh, waiver of the wrongful act, and finally, estoppel. And these doctrines will affect both the investor as well as the state, depending on the actual facts that emerged.
Sure. So, just a little one more question, and then maybe we can request you for your concluding remarks. But if an investor had possibly done it knowingly, but forcibly, uh, and it comes to the knowledge that yes, there was no other option but to do it in this way, can state deny that look, maybe this was a norm, maybe this was a forcibly done, you had no other option, and maybe one of our officers did it during or outside the scope or whatever may be their defense, but the very fact that there is corruption, will that in itself disentitle the investor to its claims, or that may lead to some other consequences, but so long as they have not actively participated in corruption, let's put it that way, or it is not initiated on their behalf, or it was not done to trip the other bidders at the time of investment or otherwise, is the fact enough, or there has to be something little more?
The law isn't clear on that. I think the general weight of jurists' opinion is that there is a difference between an investor who is the claimant and then it's shown that he acquired his investment by corruption, uh, and where he's claiming on treaty rights, and then the state's defense is that there was corruption. Then he replies, "Ah, yes, but you forced me to do it." But again, the weight of authority or the weight of juristic opinion seems to be that if an investor either initiated the request for try to offer to pay a bribe, or he was asked to pay a bribe and he actually complied with that request, then usually he will be barred by one of those defenses
Sure.
from relying it certainly as a ground for his, if he is in the claimant or if the whole state is claiming against him,
Sure.
maybe he has a defense.
Okay.
But this is a little bit theoretical.
Sure. Thank you. Any concluding remarks on this subject as to while evaluating any of the claims, even before starting, what kind of detailed inquiry, let's say an investor or the lawyers or the people analyzing the potentials should do, or and whether they come across something like this, should it be upfront disclosed? Should it be something which can only be used as a defense? Any advice or any thoughts as part of your
And
concluding
just to add
remarks?
to Vyapak's point, at what stage do they put in this defense? Do they have to? Does it make a difference if they do it in the first pleading, or they do it after a couple of months in the dispute, or maybe an afterthought? Or what do you see in your experience?
You're asking the wrong person. I'm not the person who's usually there at the beginning. I'm the person who looks at the results and then makes a decision. But all I can do is to refer you back to the classic case of World Duty Free against Kenya, when I'm not quite sure why the investor in the first place, if you recall, he was the one who himself raised the issue of corruption after he had actually started his claim, which was, by the way, a contract claim and not a treaty claim. And then halfway through, he suddenly disclosed that he had paid this bribe to the president. And of course, at that moment, then Kenya said, well, extirpe causa, you can't base an action for compensation when you yourself have been guilty of an act. And fortunately for Kenya, they were able to rebut the other argument that was being raised, which is that, but he's your president, surely there cannot be a better example of a state agent than the president who asked me for a bribe. And they said, well, we as a state never knew about it. And had we known about it earlier, then we would have taken the action. And so the tribunal, although it was really, I think, going back and forth a bit, at the end of the day had to accept that as there was no evidence that Kenya had actually acquiesced or adopted that bribe, and therefore disqualified, if you like, the claimant from that claim. Not everybody is so certain that the correct decision was reached in that particular case, but that gives you a pointer.
Sure. Thank you.
Thank you so much for your
Thank
time.
you. Thank you so much for your time. And that concludes our second interview in this series. And look out for the space, because we are going to come up with our third and the fourth interviews very shortly, and we'll make announcements about the interviewees and dates very soon. Thank you.
Thank you.